So I will try to be less romantic but more optimistic. And my lecture will be also about the language, or the concepts that are very often used in politics, law, and most recently in philosophy also. So my lecture is going to be about the concept of peoples. The people are generally seen as the source of democratic law. In general, contemporary democracies, or rather their governments, are taken to be legitimate only if they are responding to the will of the people. Preamble of the Constitution of the USA starts with "We the people of the United States." If we look beyond the state, in the times of globalization and migration, international relations seem again to be based on the will of the people. The preamble of the UN Charter starts with "We the peoples of the United Nations, determined," and so on. International law, which is decided upon in most cases by the sovereign states, can be contested by the peoples. So, the General Assembly Resolution 1514, all the peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. Hence, it seems that these peoples are the determinant factor in the legal and political life overall. So this paper asks a philosophical question about how the people should be defined, conceptualized, and finally legitimized. Hence, it will look at both ontological and political perspective of the peoples. The discussion here links to three pillars: actual international legal documents, John Rawls's definition of political institutions, and finally John Searle's discussion of social ontology. So I have a lot to talk about. So I intend to start my analysis by the discussion of international legal documents, and then backtrack to the possible theoretical, political, and ontological assumptions. So, peoples in international law. I will also throw at you some bureaucratic legal language. Today's international law grew of the idea of jus gentium, which direct translation of jus gentium would be the law of peoples or law of nations. The law was used in Roman law to refer to two different kinds of legal relations. It was the law that regulated the relations between independent states. Therefore, it was a part of public law that foremost settled questions of war and peace. It was also the law that regulated life in Roman colonies and their relations to Romans. So it was a part of civil and private law, since it dealt with the relations between individuals or social groups within the Roman Empire. Thereby, the word gens, the people, from jus gentium, means either a sovereign state or a social union in the form of clan, tribe, race. The meaning of jus gentium in either of the two versions refer to some regulations that go beyond certain borders, either those of clan, a union, or those of sovereign state. Today, a law that goes beyond and across borders is called international law and is considered to be a successor of jus gentium. It consists of legal documents between sovereign states about war, peace, and many other things, as well as transnational agreements on trade, cultural affairs, etc. In English terminology, this law beyond borders refers to nations, as in their basic units, international, while in German it refers to people, Volk, like in Völkerrecht. It is a matter of common agreement that the basic unit of international law is a sovereign state, which is still its legitimate legislator, as well as the ultimate executor of this law. However, an individual, population, or people, in the form of distinctive social unions, are ever more gaining their distinctive place within international law. On one hand, this has to do with the development of democracies and growing number of democratic regimes, and on the other, with the concept of globalization and the ever more interconnectedness of people beyond the state borders. Both of these phenomena are closely connected to the concept of self-determination. Self-determination has to do with the collective right of some group to govern themselves, which is said to be the basis of the democratic principles of law and politics. Two practical problems arise immediately from the concept of self-determination. The first is about the scope of the population referred to by the self part, or as Christian Tomuschat calls it, the ratione persone of self-determination. The second problem is about the final outcome of the goal that is to be achieved through the self-determination, again according to Tomuschat, the ratione materia. The two problems are interconnected. depending on how widely or narrowly we define the scope of persons who are to be granted the right to self-determination. We are also to define their eligible claims. Example, statehood, federal union, some sort of political autonomy. The other way around is also possible. If the ultimate goal of self-determination is seen exclusively as leading to independent statehood, then not all groups can be granted this right, since otherwise none of today's large states would exist. This means that either self-determination does not necessarily assume independent statehood, or the persons that are allowed to self-determine themselves are a priori co-nationals. The first distinctive portion of the population that was explicitly given a right to self-determination was the population of former African colonies. Their territories in Africa were conquered in the 16th century by the great European powers, and the population was placed under European rule. United Nations Resolution 1514 liberated in 1960, liberated those territories and explicitly gave to the peoples a right to self-determine their political systems. So it has already been quoted, all peoples have a right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. What did this mean in practice? Colonial population, following years of guardianship, did not have the human resources or the know-how strategies to build their own institutions. Giving them independent statehood also assume supporting them in making their institutions work. The peoples were still in the need of guidance, assistance, and supervision. The difference being that this time the period of supervision was to be limited. In addition, the awarded statehood did not necessarily follow ethnic or racial lines, but was determined along the borders that Europeans, that means the colonial powers, had set. This was again a political decision, since otherwise the newly independent states would have ended up in endless disputes or maybe even in a war. As Resolution 1514 introduced the idea of peoples and insisted on its inalienable connection to the idea of self-determination as the counterpart of the non-interference or non-subjugation to foreign rule, but did not specify the characteristics of the people or what kind of political autonomy self-determination implies. Another population group, the Palestinians, in this case the same ethnicity, was granted the right to self-determination not long after the Resolution 1514. When the British government retreated from Palestine in 1948, Jewish settlers in the region quickly proclaimed the Jewish state of Israel. Palestinians did not have enough time to organize their future. After the Arab-Israeli War in June 1967, Israel occupied the Gaza Strip, the West Bank, and East Jerusalem. General Assembly of the United Nations recognized that the Palestinian people have the right to self-determination, which is Resolution 2535. The European Council joined this recognition. The specific ethnicity, however, is not being granted an independent statehood, but rather another form of political autonomy. Hence, if by peoples only a part of the population or a specific ethnicity of some already existing state is meant, like in the case of Quebec, Basque Country, the Kurds, etc., then self-determination does not necessarily mean granting them independent statehood. This does not, however, again mean that these ethnic groups or parts of the population would not have certain linguistic, cultural, or even political rights. On the contrary, the rights and needs of these groups need to be accounted for within the political system of the state in which they live. The system needs to allow themselves to self-determine themselves even without an independent statehood. Being under foreign rule does not mean that this rule needs to be despotic or disgraceful of the people's culture. An extreme example of having a different moral or cultural codex from that prescribed by the state is the lifestyle of some indigenous people. They still live in their traditional way and did not assimilate to the life of the state's majority. How should both the indigenous people and the state deal with this? Resolution 54 of the Subcommission on Prevention of Discrimination and Protection of Minorities grants indigenous peoples a right to self-determination. This provision may be read as a call for a breakaway from a state in which indigenous peoples currently live, or it may be seen as a call for some form of internal political autonomy. It is certain that a group who has a distinct culture has a certain right to self-determination. Rights of a certain group to specific cultural practice are embodied in various international documents. For example, the UNESCO Declaration of the Principles of International Cultural Cooperation from 1966, the Universal Declaration of the Rights of Peoples adopted at Algiers 1976, Banjul Charter of Human and People's Rights of 1981, etc. All these documents use the notion of peoples when talking about cultural rights. These documents were not written, the last one I quoted, are not written or signed by any governmental officials, but by a group of like-minded international lawyers who find it necessary to stress and pursue the topic, even if only as a policy paper. However, none of the documents says the political status of culturally specific groups need to be that of a statehood. What is being determined through self-determination is their culture, their social and economic well-being. This can be done within a group, association, and ultimately within a state. Peoples are thus active on all levels. Hence, international jurisprudence uses the concept of peoples in three different ways. First, the peoples are seen as governments of a sovereign state. In this sense, the peoples means that the government is a legitimate representative of its population and as such liable for making decisions on behalf of the population in matters of domestic and foreign policy. The usage of the people is to be found in many documents of national and international law, like at the beginning cited preamble of United States Constitution. The second usage of the peoples in international legal documents is in the context of a specific ethnicity within the state. Here the people is seen as a challenger to the state's sovereignty. It is highly likely that the rights of the peoples are being violated by the states, and therefore international law is set up to protect the peoples and their right to self-determination. Finally, peoples may be seen as a synonym for a specific international regime as a whole, or as an emerging civil society that is fighting for the rights of groups and individuals everywhere. So we talk about the peoples of United Nations, for example. So what I have hoped to make clear in this first part is that despite of its frequent usage in legal texts, neither the notion of peoples nor their influence on the international relations and international legal system is obvious. Many different kinds of people seem to exist and exercise their influence. In what follows, I will investigate whether philosophy can bring conceptual clarification into the concept of new national identities within a people. A people consists of communities of mutual recognition and mutual commitment. They are usually, but not necessarily, early historic communities which stretch back and forth through generations, and as such are sources of obligation. Finally, people have common public political culture, which makes for their national character. Hence, people respect different ethnicities. Where ethnicity finds its aspirations denied, it begins to think of itself as a nation. Then it either gets his aspiration fulfilled through an independent statehood, or the people or the government of the state that already exists accounts for the needs of that ethnicity. Hence, Rawls's peoples would accommodate many ethnicities that would share a common public culture and see themselves as one nation. All the ethnicities would consider themselves free, satisfied, self-determined within the one people. Finally, peoples have moral nature, which means they express a firm attachment to political, moral conceptions of right and justice. The moral nature of the peoples makes them act reasonably and not just rationally. and they do so out of the conception of justice they, or their population, adopts. The reasonable behavior is inherent in each people's conception of justice and means they are taking the interests of others into account instead of acting on purely rational grounds. Peoples have ability to rethink and revise their conceptions if they collide with those of others. They are either already moral agents, tolerant and self-constrained, or have a capacity of moral learning, which means open for consultation and cooperation. Moral nature of the people develops gradually and parallels the maturing of the political system. Moral nature accounts for the cooperation between societies. Or peoples, well-ordered societies, learn the value of dialogue, reflection, and tolerance internally and applied in foreign relations. They build cooperative agencies between societies. With time, they develop an affinity towards each other. The final outcome being that cooperation is accepted as a part of each society's political culture, or rather its moral nature. As a consequence of these three characteristics, or necessary conditions for the creation of peoples, peoples do not have the two powers typically assigned to the traditional sovereignty: the right to go to war in the pursuit of states' policies, and the right to autonomously deal with its own people as they please. This reformulation of sovereignty does not mean that the legitimate government loses its authority to enforce the rule of law. It merely forbids private violence and abuses of the rule of law domestically and internationally. The government, in Rawls's ideal theory, is effectively under the control of its people. It expresses the will of the people, and in such a manner that the people govern themselves. Hence, the peoples are so constituted that they do not give up on a normative individualism or the notion that political and legal institutions and practices are legitimate only to the extent which they can be considered to be justifiable from the perspective of the individual who constitute them and is affected by them. This is exactly what they are in Rawls's people. To summarize, for Rawls, the peoples are, for once, completely accountable to its population, no matter what ethnicity, race they pertain, as long as there can be a minimum mutual understanding when political institutions are in question. That means people's government is a representative and effective agent of a people, or, as it is also called, the political organization of the people. And secondary, only peoples can be trusted to cooperate fully on the international level, hence only peoples are eligible for the cooperation, economic or cultural, with other societies. Hence, Rawls's view, in Rawls's view, it is very clear how international law should look like. The treaties should be done only and solely by the peoples. The rest of the world would be given a helping hand until it constitutes itself into peoples. The question is now, of course, what about the other societies that are not well ordered? Are there any peoples in them? Certainly there are persons or social groups, but if government acts unjustly, domestically or internationally, the government will have to be seen as a body that acts only in its own name, not in people's name. It is a free-willing agency. It deserves the position of the people, and as such has, according to Rawls, no standing under the international law. In order to completely understand this, let us go one more step back and ask about the social ontology of these peoples. When we talk about social ontology, it has traditionally been focused on one general issue, that of how individual agents relate to society. Usually it is assumed that individuals relate to society's parts relate to the whole. And then the question is whether the whole is something more than the sum of its parts, whether the parts are transformed through belonging to the whole. John Searle, in his groundbreaking work, The Construction of Social World, and many essays to follow it, explains our social reality in the following manner. The basic structure of the world is pretty much as described by physics or chemistry. Ultimate reality consists of entities we find inconvenient to call particles. They are organized in systems. Their causal relations define these systems. Some of those systems are organic systems. Some of the organic systems have consciousness. With consciousness come intentionality, and when we have consciousness and intentionality, we have reached the evolutionary stage of animals, mammals, and especially primates like ourselves, who form social groups. Now, when we want to decipher the way these social groups function, and primarily to ask about the possibility of political institutions, we come to the problem that goes beyond the physical, and that Searle calls intentionality or consciousness. It is clear how everybody can have I intentionality, but it is not clear how a group, if it is to act as a group, creates a we intentionality, and in what relation does this we intentionality stand to I intentionality? Can a collective intentionality, or as Searle calls it, we intentionality, be reduced always to I intentionality as a simple sum of its parts? According to Searle, no, and there is no reason why it should. When we are doing something collectively, we simply use we intentionality. I have I intents that I have precisely because I have an irreducible we intent. To nail that down to cases, I'm indeed playing the violin, and you're singing the soprano part, but I'm only doing what I'm doing, and you're doing what you're doing, because we together are collectively playing the choral movement of Beethoven's Ninth Symphony. Furthermore, Searle argues that there is a distinction between two types of norms, constitutive and regulative. Some rules regulate antecedently existing forms of behavior. For example, the rules of polite table behavior regulate eating, but eating exists independently of these rules. Some rules, on the other hand, do not merely regulate an antecedently existing activity, like playing chess. They, as it were, create a possibility of that activity. The activity of playing chess is constituted by the action in accordance with these rules. Chess has no existence apart of these rules. The institutions of marriage, money, and promising are like the institutions of baseball and chess, in that they are systems of such constitutive rules or conventions. According to Searle, institutional facts like marriage, money, and private property emerge from the independent ontology of a brute natural facts through constitutive norms. This is exactly what happens in Rawls' version of social political reality. A well-ordered society is a clearly collective agent merged through constitutive rules and brute facts of the existence of certain people at certain territory. The people have, besides I intentionalities, for example, fulfilling their own life plans, also we intentionality in the sense of fulfilling the conception of justice, which they fulfill through common institutions. It is the society which takes the brute fact of cultural pluralism and personal differences and orders them into well-ordered or just political institution. Institution is a public system of rules which defines offices and positions with their rights and duties, powers, immunities, and the like. These rules specify certain forms of action as permissible and others as forbidden. People correspond to their members' sense of justice through their constitutive conditions or rules, their government, common culture, and common moral nature. The relations of peoples are then regulated by international law. However, the rules that coordinate state behavior are regulative, not necessarily constitutive. Peoples are seen in an analogy to the natural persons, but since they are being moralized self-sufficient, their behavior towards each other needs to be just regulated so it would be even more effective. Searle gives example of the regulative rule. Some rules regulate antecedently existing activities. For example, the rule drive on the right-hand side of the road regulates driving, but driving can exist prior to the existence of the rule. Cooperation among peoples that have moral nature will certainly exist. With international legal regulations, it can only become more efficient. International law, according to Rawls, does not create a very possibility of international cooperation between peoples, but it gives it certain balance and structure. The ontological character of peoples as grouped agents with we intentionality explains Rawls' understanding of well-ordered society and offers a conceptual definition of peoples, which as such can be used for redefining the idea of peoples we find in international law. And now, I said at the beginning that my aim of this paper, the aim of this paper was to conceptualize and legitimize the concept of peoples. Its conceptualization I hope to have made at least a bit clearer. However, its legitimization is still open. By legitimization, I mean the problem that Thomas Schadt points to when he discusses the distinction between ratione persona and ratione materia. Or in other words, it is obvious, or at least I hope it is after what has been said so far, that the government is only legitimate if it represents people. But what makes exactly these people legitimate to form government? As Thomas Nagel says, that the path to legitimacy runs to illegitimacy, a lesson of cunning of history. Hence, the peoples are contingent brute facts, and people living today in some communities cannot invent new ones completely, but that they can fully reflect on the existing ones and change or endorse them. Reflection and debate as a tool for countering historical contingency are once more an impulse for international law to revise its membership, and instead of asking a question of how much people within and beyond already existing sovereign states there is to be accommodated, international law should ask how many peoples, as well other societies, it needs to regulate, and how many societies still need an impulse to becoming well-ordered. Thank you.